Ready, start. Leave granted, full stop. The appellant was a minister in the government of the state of Gujarat, who after his resignation was proceeded with under the Prevention of Corruption Act, 1988, full stop. The allegation was that with an intent to obtain illegal gratification, fishing contracts in the reservoirs vested with the state were allotted without following the policy of the government, mandating tender proceedings, full stop. The appellant is before us challenging the order of the High Court refusing to quash the criminal proceeding initiated against him, full stop. The complainant, first respondent herein, inter alia engaged in trading of fish, was desirous of obtaining fishing contracts by participating in the tender process, approached the High Court challenging the illegal grant by way of allocation, without any tender process, full stop. The High Court cancelled the grants and the state was directed to proceed to make such grants through a proper tender process, full stop. The complainant asserted that the tender process culminated in grants to successful bidders which clearly generated more consideration for the state, indicating the attempt of accused numbers 1 to 7 to obtain illegal gratification by making such peremptory grants to those who promised them to pay the demanded amounts from the proceeds received from the grants, resulting in huge loss to the state, full stop. The appellant herein, who was arraigned as accused number 2, asserted that the grants were made to help the tribal community and the beneficial distribution of largesse of the state, to the marginalized sections of society was not with any intent of receiving or obtaining illegal gratification. Full stop. The additional sessions judge anti-corruption bureau rejected the discharge application which was sought to be challenged under section 482 of the Code of Criminal Procedure before the High Court, unsuccessfully, full stop. Sri Mukul Rohtagi, learned senior counsel appearing for the appellant, pointed out that the records indicated that there is not an iota of material to allege corruption by the appellant, who is the second accused, full stop. The complainant had approached the High Court in the year 2008, with a writ petition to cancel the grants, and the first complaint alleging corruption was made for latter, in the year 2012, that too only against the Minister of State, who is the first accused, full stop. It was later that the special court issued summons to the accused numbers 2 to 7 alleging offences under sections 7, 8, 13 1 A, 13 1 D and 13 2 of the Act, based on an investigation report which clearly found that there was no case made out, of corruption, against the second accused, full stop. There is not even an allegation that the appellant demanded or accepted bribe, for the purpose of issuing the grants, in the investigation report or in the statements recorded from the persons questioned by the investigating team, full stop. The grants made on prefixed upset price was to benefit the Padhar Adivasi community, which is made possible by the policy framed by the Fisheries Department, approved by the Cabinet and the Chief Minister, as found in the investigation report itself, page 109 to 113 of the memorandum of SLP, full stop. According to the learned senior counsel, the High Court erred also on 2 counts, 1, insofar as the finding that the earlier judgment in a similar application filed before the High Court, had pulled the shutters down on a subsequent challenge on the same ground, full stop. It is pointed out from the earlier order that the learned single judge of the High Court had specifically left liberty to the petitioner to file an appropriate application for discharge, after pre-charge evidence is recorded, while also holding that there was no good ground to interfere at that stage, full stop. The second error committed by the High Court is, insofar as peremptorily coming to a finding of corruption, without looking at the material collected by the investigating agency and without examining the records properly, specifically, the pre-charge evidence recorded which clearly indicated that there was no corruption in the grants made by the Department of the Government, which was also only to ensure distribution of state largesse to the marginalized sections of society, specifically the tribal groups, full stop. The allegation of violation of policy are a mere peremptory grant made, without following the tender process cannot lead to an allegation of corruption under the Act, as has been held in Neeraj Datta versus State NCT of Delhi by a constitution bench of 5 judges, full stop. It is also argued that the suspicion, which restrains the court from discharging an accused without a trial, should be premised on some material which commends itself to the court as sufficient to entertain a prima facie view that the offence is committed, as held in Deepak Bhai Jagdish Chandra Patel versus State of Gujarat, full stop.